This concept of brokerages that are looking for workarounds, that's something that I would be very cautious with. And I would throw that warning sign out right now that if you're looking for a way to kind of get around the provisions of the settlement agreement, I would be very, very concerned for you and be very cautious with anybody who's looking for what they, would be an exception or anything that allows them to kind of skirt the provisions.
Welcome back to Nevada Realtors Today, your place for timely updates on the news and trends that matter to realtors in the Silver State. Now let's join your Nevada Realtors President, Brandon Roberts, and Nevada Realtors CEO, Tiffany Banks, for today's episode of Nevada Realtors Today.
Okay, today we have the pleasure of hearing from Piers Tueller, Senior Associate at Hutchison Steffen, who's been on the front lines working on many of these practice changes with us as a state for the Nevada Realtors. And so he's joining us here today to talk about the impact the settlement has on the realtors, potential changes or reforms that could occur in realtor practices or the industry. And as generally speaking, just the settlement, what really should be included in these buyer-broker agreements. Do they really have to be titled buyer-broker agreements, or can they just be written agreements that comply with the terms of the settlement? So we're here to just chat through all of that. But before we get started, can you just tell us a little bit about you and your background?
Oh, for sure. So first of all, it's a pleasure to be here with you both. It's been fun to work with you over the last few months. Unfortunately, as an attorney, I don't typically get to meet people unless there's been a problem or an issue. But nevertheless, this has been fun to work with, and I'm excited for the future of your industry. Typically, when there's a settlement, there's compromise, there's changes, and it can be intimidating and scary. But nevertheless, with the realtors, I think the future is bright. So for me, I have been an attorney at Hutchison Steffen for a little over 7 years. I practice in a few different areas. I do complex commercial litigation, antitrust litigation, and administrative and regulatory compliance law. Which essentially means that I work with businesses and organizations within any industry that may have some sort of an issue with the government or trying to get some sort of licensing done. I'm not from Nevada, but my wife is. She's a proud fifth-generation Nevadan. And so I am quite proud to be living in Las Vegas and raising my family here. When I'm not working, I spend a lot of time traveling. I love to hike. I love to run. Anytime I can be outside is a fantastic thing for me. Aside from that, when we're talking about legal cases and legal work, typically what we deal with in these types of cases is we'll help clients through the entire litigation process from beginning to end, complaint to trial. And as what happens with, 95+% of cases, things settle. And so typically what we'll provide here at the firm is advice and guidance and counsel on how to navigate settlement agreements and how to allow the issue that has been resolved to truly be resolved. And it's a fantastic job.
That's incredible. And when you think about, and I think you had mentioned the word opportunity, but when you think about working with clients and what a settlement means, is it an opportunity to do things a different way than you've done them? Like, how do you reframe again in your clients' minds, or like what something like this big NAR settlement means for our industry from your perspective?
Yeah, that's a great question. So to maybe put a little extra flavor on it, when I was in law school, I took a class on mediation and alternative dispute resolution. And my professor in that class talked a lot about how compromise can often be really frustrating for all parties, and how when parties enter into a settlement agreement, they typically feel like they're losing something. And so what's important to remember is that when you enter into a settlement agreement, in this case, when we're talking about the NAR settlement and the effect it's going to have on realtors everywhere, is that there is going to be a little bit of compromise. But I also think that it's great to realize that when you look at the terms of the settlement agreement, you also see a new and what I would say a higher way of operating that's going to allow brokers and agents who are willing to work hard, who are already working hard, who are already doing their best, are going to continue to see such an amazing benefit. Because really what settlement agreements do is they just provide a little bit of clarity and transparency where there may be some ambiguity and disagreement as to specific terms of the deals in the past.
I think that's a great point. And I think, we have heard the word transparency as well a lot recently, and everything that we've done as far as, our guidance for the Nevada Realtors for the last 10 years that I've been in this position is it's the consumer is the center of the transaction, making sure that they understand what they're getting into. And you have the help of the realtor helping them make the largest, possibly, most likely, largest financial decision of their life. But what does that look like as far as consumer transparency? And I know, like, the three of us have talked for the last 6 months or longer over really highlighting that. What do you feel like is the right things that we're doing now and kind of in the future that we can do to make sure that we continue to put consumers first?
Yeah, that's a great point, and you're right. And like, what's hilarious about this is that we're talking about a industry that is designed to help consumers, everyday people, make the single largest financial decision of their lives. I remember when I first bought my house, I was terrified, and I was looking at these documents, and I had my agent there with me, and they were going through it with me, and I was just thinking, this is beyond overwhelming. I can't believe I'm doing this. And so, what's great about the settlement, and we can kind of talk about some specific provisions, is that the ultimate goal here is to remind the consumers that everything is negotiable. All consumers have the ability to take a provision from their contract, to take a provision from any agreement they have, whether that's with their broker who's going to help them find and buy a home, or whether that's with their broker who's going to help them sell a home. And they can negotiate and they can come up with an arrangement that works for all parties. Now, what happens typically in cases where you have an industry that deals with these agreements on a daily basis is it becomes old hat. Good brokers and good agents are selling dozens of homes a month, hundreds of homes a year, and they see these agreements every single day. And the terms become almost, common parlance, and they forget, and it's easy to forget that some of these terms are overwhelming. The idea of exclusive representation, or broker compensation, or cooperating brokers and things like that can be very overwhelming to somebody who up to that point has had zero experience with the real estate industry, except for maybe watching a couple episodes of $1 Million Listing, right? So it's
Show? Is that your favorite show?
hey, you know what? I will not pretend that I don't dream of a vacation home in the middle of a beach somewhere,
Especially right now.
especially right now. Yeah, so it's like I love the idea of consumer transparency because, again, I think that you have a fantastic industry, and Nevada Realtors has created such a great culture of operating at the highest possible level. And all the settlement agreement does is enumerate that desire to help keep consumers in the best possible position.
I agree with everything you just said because I think communication, as you get comfortable in a thing, you don't educate or spend the time to share the information because you just think they understand or they know. And we use all kinds of acronyms like RPA and CMA and BBRA, and we use them as like old hat, but you can make a consumer feel inferior or not understanding. So one of my favorite things that's come out of this settlement is the fact that now you need to sit down and actually spend some time with that consumer on the process and everything that's going through. And by getting that initial document signed, which doesn't have to be a exclusive right to represent, but it needs to be a written agreement, correct?
Absolutely. And what's interesting, and what a great example of what you're talking about, is this idea that before brokers start to work with a potential buyer, or they start to show them a home or tour a home, is that there is this requirement that they need to have some sort of a written agreement in place. That way, the consumer is very clear whether or not that broker is going to be operating in a way that can be considered representative or as an agent, or whether or not it's just a very specific, very limited scope of representation. We've all walked through open houses, or we've all tried to go see homes. And, if you're talking to a broker and you're asking questions and you're looking for some information and you're looking for help, and the broker may be excited about the idea of working with you, they might try to give you some other examples of some other listings that are comparable to that home that you're touring. The consumer may be confused about what actually is happening there. And they may not realize that broker or that agent might not be their agent or their broker. might just be trying to be helpful. And so by requiring additional written agreements, by requiring a little bit more specificity, it's all about removing that ambiguity and helping the consumer be very clear about who's helping them, who's engaging with them, and ultimately what they're able to do with their representative or their agent. And it's tough, right? Because everybody is very concerned about the costs associated with the purchase of a home, and not knowing exactly what you're going to have to pay an agent or a broker is intimidating and adds stress to an already stressful situation.
Mhm. And I think the things that, we hear that are the positives are, like nobody else is setting your value. Like you're able to articulate as a buyer's broker, this is my value. This is what I have to offer, and this is what I deserve to make, buyer. And obviously anything else that comes from the seller through a avenue like an offer is great, but they're able to articulate early on of like, this is the relationship that I want to have with you on the onset buyer broker. And again, anything else that comes after that is great. It just can't be more than what we agreed to.
Right. And what's great about that is when you actually look at the terms and the language of the settlement agreement and what's required, and obviously the settlement agreement itself is a very long document. And if anybody does have any specific questions about whether or not these provisions apply to them or how they should apply to them, I would always recommend that they hire their own attorney. They go seek out legal counsel to give them specific advice and an analysis of their specific problem. But generally speaking, when we look at the terms of the settlement agreement, we're talking about paragraph 58, which really lays out these changes and how the effect of what we're talking about on the consumer needs to be practically implemented. So specifically, when we're talking about written buyer agreements, paragraph 58 has about 4 or 5 specific changes. And the big one is to specify and conspicuously disclose the amount or rate of any compensation that the MLS participant will receive from any source, or how this amount will be determined, right? So percentage or specific dollar amount. The second thing that it talks about is the amount of compensation must be objectively ascertainable and may not be open-ended. So typically, and Brandon, I would love to see, hear your position about how this was done in the past. But I know that a big problem years ago was these open-ended phrases like buyer broker compensation shall be whatever amount the seller is willing to offer to the buyer, which is incredibly ambiguous and a little scary.
Yeah. People would put stuff like that in the buyer broker agreement, but the bigger scary thing for me was that there was so many transactions done without a buyer agency agreement or some kind of agreement to hire that agent to go out and sell. They just assumed that they were going to get paid on the other side. And I think that's what got us into a lot of the trouble. Is the fact that it appears that the seller is always paying that commission, and the buyer didn't have the right, or the seller didn't have the right to negotiate that fee.
Yeah, that's a great point, and I think I think the settlement agreement did a good job of covering that by having a couple of additional provisions where, what now needs to be conspicuously included is that broker commissions are not set by law, are fully negotiable, and that the MLS participant, in this case the broker, may not receive compensation from any other source that exceeds the amount or rate agreed to with the buyer. Again, it's all about eliminating the question marks and having that specific provision, which frankly, from an attorney's perspective, is what we're always striving for, is very clear, very thoughtful contracts.
Do you guys think procuring cause will be less of an issue now? Because procuring cause, when I worked the legal information line for many years, I'd say that earnest money disputes, procuring cause, and like something like a basement flooding in the middle of escrow, what do I do? Or like the top 3 types of questions you always got. And so when we discuss procuring cause, we'd always say, if there's a break in the chain of the relationship, essentially, like that's what you're looking for to say that procuring cause doesn't exist, if there's that break in a chain. But it was like also very ambiguous of like, what does a break in the chain mean? And so do you think buyer broker agreements for all will actually take out a lot of those procuring cause type of arguments?
Yeah, and I think that's a great example. So to use something not real estate related, I do a lot of work with startups and young companies, and the biggest problem that I see with a lot of these folks that come in is that they're entering into a business arrangement with a friend, a family member, and they go, "Oh, we got this. We work well together. We've been friends for 20 years. We don't need to write anything down. We all understand."
Hmm.
And sometimes things just happen, and sometimes circumstances change, and that's not necessarily a dispute. That might be a death of a partner, right? And then the other partner is trying to scramble to figure out what happens with their business. And when you have things written down in the case of a business, an LLC, like an operating agreement, you have a clear set of obligations and responsibilities. And what's nice about mandating buyer broker agreements or specific provisions within the buyer broker agreement or some sort of written agreement is that you remove that question mark, just like in a normal business setting. In the forms that we've been putting together and we've been circulating around, and the ones that I've been reviewing, and what's been interesting looking at what organizations and brokerages are doing across the country, one kind of common theme that I'm seeing is that everyone is being very clear about buyer obligations and broker obligations. And they're including these provisions in there just so that everybody knows what exactly is going to be done. For example, kind of a standard language that I've been seeing for broker obligations is that the broker will agree to provide buyer with reasonable skill and care and protect the best interests of the buyer. And what's funny is you put that language in there and you're like, well, that doesn't necessarily mean anything, but it's important because then it can start to set the tone for transparency in compensation, transparency in authorizations, and ultimately a full disclosure as far as what's going to happen over that course of that transaction.
And that you are that fiduciary for your client. Because I think that often is bringing to light that I am representing you in that capacity.
Right. And what's great to remember as well is for a lot of brokerage for brokerages and agents is that they hold licenses. And as a holder of a license, they have that higher level of obligation to their clients, and they have a code of ethics that they need to follow. And what's nice is it just reminds the consumer that they're dealing with somebody who is operating as a professional and is looking for opportunities to be clear.
So Tiffany, when you bring up procuring cause, it's interesting because a couple of my management team, we've had this debate over procuring cause being dead or not, because in procuring cause, and I don't know how it applies in all the legal forms, but for the realtors, it's been broker to broker because there was an offer of compensation being offered. And then they paid one broker, and the other broker argues that they're the reason that buyer bought that house. And so with no offers of compensation, to me, procuring cause is dead. But I guess where you run into the biggest issue is if this buyer was to sign multiple agreements with multiple brokers. I mean, and I don't know if this goes down to legal advice or whatever, but does the judge look at something like procuring cause, which one was the one that actually got them to the house, or would the buyer possibly be obligated to pay both?
Yeah, that's an interesting question. And what's interesting, yeah, in thinking about that, when you have somebody entering into multiple competing contracts, there's going to be a problem there. And this is and maybe not to give you a classic lawyer answer of it depends, but maybe to pivot a little bit. If you look at what the settlement agreement also does in the way that it requires compensation offers to be moved off the MLS, I think this is designed to encourage broker to broker communication, where you need to actually get on the phone or you send an email and have a bit of direct communication with somebody else on the other side of a transaction. Now, again, I know this isn't directly answering your question, but I do think that this is an interesting point, that it is designed to further increase the level of negotiation and discussion, and ultimately to protect clients, buyers, or sellers from this sort of confusion. I mean, if I'm selling my home and I sign 3 different agreements with different brokers, then that's going to be a problem for me. but it's also going to be frustrating for the brokers. But all of this, everything that we're doing here is designed to continue to highlight and essentially force increase negotiation and discussion.
And I think that, again, this new norm of what we expect, like all these questions, I think are going to come up as we start to, really analyze the difference between, exclusive versus non-exclusive buyer broker agreements, whether they're for the property for a specific period of time. I think all of that will kind of flesh out these other things again, like recurring cause. Maybe we'll start to see some of those arguments. And it was actually, I think it's very, very, very difficult to even, to Piers's point of it depends. There's a lot of facts that need to be fleshed out, like with any other essential contractual dispute. You can read, what's in the four corners of a document, but at the end of the day, you're looking at what all of the facts are really speaking to for that result. And again, I know when I got the calls on procuring cause, everything was so fact driven, and it absolutely was like one realtor said one thing, and then if I had an opportunity to hear the other side, those facts happen to be far different on the same exact transaction. And so I think, again, this is a good reminder to our members of, like we don't have all the answers today of what, like what the settlement means, what all of these, like all the questions that will come up, but we're going to do our best to try to navigate and anticipate the questions, and essentially like what the arguments would be for both sides to make sure that we're able to give you guys the best advice, as far as an association goes, and like guidance, mainly like what resources and guidance can we offer to you to navigate these times?
I think overall the settlement's a good thing. I think it causes agents to be better. It opens the lines of communications. And I think the really good agents will probably get a raise, and the not so great agents will probably either get out of the business or work for less. But I think dollar follows value. And so some agents will be able to demonstrate that value better than others. My concern is that I think that having this agreement signed prior to showing homes may be a little soon. And my fear of that is that buyers will be signing agreements without doing homework, without understanding the different value propositions of different agents and brokers and stuff like that. Do you foresee any issues with it being signed that soon?
Yeah, Brandon, I think you're spot on, and that's going to be a bit of a situation where I think there's going to be probably some growing pains, and I think people are going to do some things. They may reevaluate. They may try something different. It's going to be a little bit of an ongoing process. And obviously, like I said earlier, and I will say again and again and again, for any brokerage who is concerned about the way they're operating, I always recommend give a lawyer a call, spend a little bit of time with them, have a quick consultation, walk them through what you're currently doing, and have somebody give you good, solid, specific legal advice with your specific forms, your specific method of operation. And if nothing else, it might give you an opportunity to have a little bit of clarity and a little bit more peace of mind. Now, the practice changes regarding written agreements with buyers is really going to be triggered by two conditions. It only applies to the MLS participants working with buyers and is triggered by touring a home. And the question is, what does it mean to tour a home? Obviously, is somewhat covered under the settlement agreement. But really, what we're talking about here is, going to be a little ambiguous and, a little bit of trial and error. But ultimately, I think you're right. And I think the general idea that this is going to elevate practice and the good brokers and the good agents are going to do well, I think is spot on. And I think we're going to see folks who are looking to operate as clearly as they can, be very successful. Actually, kind of along that lines, and we talked about this a fair amount, is this concept of brokerages that are looking for workarounds. That's something that I would be very cautious with, and I would throw that warning sign out right now, that if you're looking for a way to kind of get around the provisions of the settlement agreement, I would be very, very concerned for you and be very cautious. with anybody who's looking for what they would be an exception or anything that allows them to kind of skirt the provisions. Because again, there's letter of the law, there's spirit of the law, and the provisions are fairly clear. The one thing that I would say that's a little bit tricky is this idea of posting the offers of compensation on the MLS. Now, the settlement agreement does allow for an intra-brokerage MLS platform to have those listed, but that's got to be limited, right? That can just be within your specific brokerage. As soon as you allow external access, that's a violation of the settlement agreement.
Yeah, and it's getting beyond the actual MLS and knowing, okay, if I want to make a flyer with a commission, that's okay. But everything that we are almost kind of more focused on right now is be less focused on, actually forget the other commission at all being offered from listing broker. If at the end of the day, seller's wearing the hat and you write it in the offer and seller decides to pay a concession essentially for that's okay. But forget offers of compensation from like co-op commission. And that sounds like very extreme, but I think that we all are in agreement with you. Like the workarounds are only going to be more harmful to the industry than just trying to do things under this new norm, because the faster we get used to the new norm, the better it's going to be for all. And especially like there was a Sierra Nevada, I think, had a new member orientation last week, and for all of their members that are new, this is their new norm, right? They don't know any different. So this is going to be, they might even be more successful than the ones that are used to doing it the same way that it's always been done.
Yeah, that's a great point.
Finding a lot of experienced agents that I'm talking to are having a lot of the biggest trouble with this. And they can't get over the fact of not knowing what an offer of compensation is going to be. And I know our boards, our MLSs and all that are in large companies across the country are basically saying offers of compensation are dead. Broker to broker payment of compensation is there. And I think if the sooner agents get that in their head and learn to ask for what they've agreed to with the buyer, if they need to get it included in the agreement, the easier this transition will be for them. But yeah, I just really think a lot of the most experienced agents are having the harder time because they're trying to do business the old way. And I'm telling them it's still the same way. You're still getting it worked into the deal if it needs to be. You're just taking a different path to get there.
Yeah, from kind of a procedural perspective too, talking about implementing these new changes, I'll just kind of, I'm happy to kind of walk through generally where this process is in the courts. So the court granted the preliminary approval of the settlement agreement back in April of this year, April 24th. And the practice changes went into effect about 10 days ago. And at this point, we're still waiting for final court approval of the settlement agreement. And that's not scheduled until November 26th of 2024. Now, NAR believes that there are strong grounds for the court to approve this settlement because they believe that it's in the best interest of all parties and class members. But as we're making these new changes and we're adjusting to the settlement agreement, we're still operating in a little bit of a gray area where we're waiting for that final approval, and things may change. And it's important to, keep yourself aware of what's going on, stay involved with your associations and your organizations who can provide those tools and that notice to help these brokerages continue to operate with these new practice changes and these new guidelines.
And then the state has actually been working on 2 statewide forms. Over the years, the locals have handled the forms that go out through their local association's forms library. But what was really important for us, and not just supporting these implemented changes, but taking a look at, having an actual form drafted by an attorney that could just be an option. And I think, again, it comes down to, for the consumers, for the members, we just want to provide an option that is workable. Again, you don't have to use it, but it's a benefit that you can actually utilize a form not created by a forms committee or otherwise, but actually by an attorney who's well-versed in what the terms of the settlement agreement say, and have that as an option to utilize. So we're really excited about the launching of the buyer broker agreement and the listing agreement for those purposes.
Yeah, and it's and what's great about it is just like the settlement agreement is designed to give the consumers more transparency and to remind consumers that everything is negotiable. The idea of Nevada Realtors or any other organization putting forms together that are available for its members' use is the same thing. It's providing options, providing different terms or things that could be used based on the transaction type, and allows the brokers to be in the best position for success.
So what's one takeaway that you feel like you can share with our members as far as their best tactical action item now and kind of in the near future?
Yeah, it's a great question, Tiffany. I love that question. So the best piece of advice or direction or what I have taken away from this entire circumstance, and it's going to be interesting to see how this case wraps up and resolves, is actually just a fundamental legal principle, and that is a contract that is agreed to by the parties, has an offer, has consideration, and it has to be accepted. And if you follow those fundamental contractual requirements, you are going to be in the best possible shape. And so when you're entering into any sort of agreement with any consumer, any buyer, any seller, if there is an offer, there's acceptance, there's clear consideration, there's clear specific terms, the better off everyone will be. And in an effort to avoid disputes and litigation and issues within the industry, it really comes back down to clear written provisions, clear understanding, and clear agreement by the parties. And ultimately, if the fundamental tenets of contract law are followed, so many problems will, in my opinion, will probably go away.
Good. So you'll be less busy?
I'm sure there will be something else that comes up, but I have no problem being a little less busy if it means that you all are operating better.
Okay, great answer. Brandon, do you have any last question for Piers?
I think his job's secure because it seems like there's still lawsuits being filed against associations and realtors and all kinds of stuff. This settlement doesn't stop us from ever getting sued. It just stops for the copycat of the original lawsuit. Is that right?
That's right. And actually, Brandon, that's a great kind of a final point maybe that we can make here is that NAR entered into this settlement agreement really for a couple of reasons. And they've said that the reason they did that was they really wanted to secure a release of liability for as many of their members, associations, and MLS as they possibly could. And they really wanted to preserve the choice consumers have regarding real estate services and compensation. Now, NAR and anybody who has opted in or is covered under the settlement agreement has not accepted or admitted liability. It's just that they're willing to change the way they operate. I would always, again, my final plug, if there's ever any questions or concerns about a way that anything is being done within your brokerage or by your brokers or your agents, call a lawyer, spend a little bit of time with them, and just know that there may be an issue in the future that we need to be prepared for. But this is a great step in removing a lot of the simple issues that can be avoided by just having clear contract terms, clear provisions, and a clear standard of practice changes that needed to be done.
Yeah, listen to your broker, utilize your broker. Your broker does know best, and your broker, for the most part, should be on the front lines a lot of these conversations, making sure that you all are protected in your business. And so we have it set up in Nevada like that for a reason. So make sure that you absolutely utilize your broker and their expertise and their way of doing things and their guidelines. I think that's a great way to wrap this up. Thank you so much, Piers, for taking the time to get on today and talk us through some of the most important terms of the settlement. And we look forward to continued conversations with you as we navigate the future.
Thank you all.